Now, welcome back to The Line. District Court Judge Sarah Singleton recently ruled that Governor Martinez did not follow proper procedures in vetoing 10 bills from this year's 60-day legislative session. And she told Secretary of State Maggie Toulouse Oliver to put those bills into law once final paperwork is submitted to the governor's lawyer. The governor's lawyer is expected to appeal the ruling and has asked Judge Singleton for a stay to prevent those bills from becoming law in the meantime. But if the judge doesn't grant that stay, the bills will take effect before an appeal can be heard. Laura Sanchez-Rivey, let's take it back here. How did we get to this place in the first place? What happened here that it, in fact, ended up going to court, and now we have this decision? What did the governor do or not do, I guess?
Well, during the course of the legislative session, basically she vetoed a number of bills, and in doing so, didn't follow what was in the Constitution in terms of a process for that. And that included, and for a number of them, not providing a veto message. So it was essentially just a veto without an explanation of why it was vetoed. And the Constitution requires that there be some explanation, and that's designed to
even just a line would have sufficed.
Something that explains what why is it that it's not something she's willing to sign into law, and that is designed to provide the legislature with an opportunity to address those shortcomings in order to try to get the bill passed and in front of her something that's much more amenable to her signature. But they didn't do that. They simply just vetoed, or she just vetoed. And so that caused a lot of lawyers and people in the legislature to be up in arms about it and challenge this decision to veto it, take it to the district court, and then the district court agreed and said, yeah, this was insufficient in terms of what she did with her vetoes. And so for some of them, she didn't do the veto message. For others, she didn't follow the process. The timing of it was not correct. So it's not exactly correct, or not the same for both. But essentially, about 10 bills are now potentially going to be signed into law, or become law, I should say. So it's an overrule of a veto by the judiciary, which constitutionally, like in terms of just our three branches of government, it's very interesting that this is how these particular laws will be signed in. Now the question is, are they going to be challenged? And speculation, I think, is that they will be, but we don't know yet whether that will happen prior to them actually being chaptered by the Secretary of State.
Right, exactly right. Interestingly, Diane, 2 hemp bills were part of that situation for research and to allow farmers to grow for research. People have been fighting this one for a long time. And getting away from the mechanics of what Laura just explained, who wins here in something like this? Is it not just the hemp folks, but is it better for the whole process that there was a win here for these folks?
I'm not sure that it's a win for the process, but I think it's something that appears, and I haven't done a lot of research on it, but it appears that it would have some value to our communities and to people. So, and as I recall, these bills were fairly tightly constructed so that you had to get approvals. You in the same process of medical cannabis is you have to be approved to do something like to sell or produce the product. The same thing with this is it's limited to growing for research. The research would have been done, as I recall, through New Mexico State University.
That's right.
Very solid, reputable organization doing the research. So I think that for us to pretend that we shouldn't look at future options, whatever they might be, I think there's some misconception out there about hemp, and I probably shouldn't have mentioned marijuana in the same conversation.
It happens.
But there is a misconception about what it's used for.
That's right.
So I think that I just don't quite understand. And I think had there been a message on why there was an objection, then I know the sponsors, they would have worked with the governor's office on this. Right. And I think we're looking at something for the future. And it just didn't seem that bad to me. So a veto message would have been extraordinarily helpful.
Another one, Harry, when I think about Diane's point about the message would have been helpful was the vetoing, or at the time the veto of configuring our computer science
Right.
and math and science requirements for high school graduation. There was not a whole lot of pushback on this. And it would have been nice to have found out why the governor was opposed to this.
And when that veto came out, it was just really, really puzzling because these are standards that are well attested to. Lots of other states have adopted them. There's been a concern about education in STEM. UNM has been doing a lot of work in this area, New Mexico State. So the lack of a message then from the governor then becomes really puzzling. Why is she doing this? This feels like a mama and apple pie sort of thing.
Right, exactly right. Mara, pick up on that again as well. The idea of a message, it's important to know why someone says no to something, so we have some clear understanding of where the administration's coming from.
Well, particularly since this is the administration of transparency. We
The most
have a
in history,
sunshine-
apparently.
Yes,
right.
we have a sunshine portal. But I think something that's marked this administration from the beginning is what I would term at best a disinterest in the legislature.
Yeah.
There's just not a big connection with the caucus and this administration. So this doesn't surprise me. What did surprise me at first is I didn't think you can sue over a veto.
Right.
And so now have we created just one more step in our legislative process? We go back and forth, we get it through the House, we get it through the Senate, it goes to the governor's office, the governor may or may not veto it, and then it goes to court.
Right.
I mean, with the temporary legislature, we don't have time for this.
That's a good point. Mary Kay Papen has come out and said, they should not appeal. But Laura, interestingly, the administration says they are on safe constitutional grounds here. That in fact, this is how they, interpreted it, and now we have some pushback from the courts. Should they in fact appeal and just move on here?
Well, I think they should just move on. But I mean, we're talking about the actual merits of the bills, and I think one of the issues we need to just, the elephant in the room is that this wasn't about the merits of the bills. And that was part of the problem in terms of why there was no veto message. I mean, the scuttlebutt at the time was that she was vetoing everything that was Senate bills. So as you see, most of these are Senate bills. There were two bills in particular that I was interested in that had to do with, that had come basically with support from a lot of the county treasurers around the state, that basically required something very easy. It was just a reporting anytime there was going to be a bond or any kind of public finance, when a tax increment development district and another district was formed, public improvement district. When these two districts would be formed, the county treasurer would be informed of that.
Seems pretty
They're
simple.
the ones that have to deal with collection of taxes. It makes sense. It's not a big deal.
Right.
The issue was that these were sponsored by in that case, Democratic senators. And the issue was that she was vetoing Democratic senator bills. So it goes back to how much are you going to play politics
That's
with
right.
these issues rather than look at the merits of the actual bill.
Yeah.
Because and that's where you kind of have to, I think that's where these people, the plaintiffs in this case, came down on, let's call you out on this because really you're playing politics and you didn't actually give a legitimate reason for why you were vetoing. Because if you had, you would have not been able to find one. You were really doing it because of political issues.
That's interesting.
So that was what they were calling them on. And now, so with that being said, though, if they push forward with a constitutional challenge still, they continue to say, I think they're on very thin ice on the whole thing.
Okay. Diane, interesting, let's pick up on that as well. The idea that perhaps it was done on purpose. You never know. There are certain kinds of omissions, if you get my drift here, that are so obvious.
Yes.
Right.
I'm bumfuzzled by this whole process because to me the Constitution is very clear. Now let me say right up front, I am not an attorney, so I don't know the legal, but as a citizen, I can read the Constitution, and having a former legislator, I understand the process. And I was trying to think back, and I checked with some of my former colleagues. This has never happened in anybody's memory.
That's right.
So, not to say that it may not have at one time or another. So it's like the process is very, very clear.
Right.
So, what's the real reason this was done?
That's right. That's right. This is not her first go-round
No,
signing
and
or
she's
vetoing
been the
bills.
governor and her staff. They're smart, talented people. They know what it says. So I'm sitting here as a citizen and former legislator going, something smells. So
That's right.
I'm just concerned about that instead of.
I think that's the overall right there. That's very interesting. We'll have to see how it goes, but apparently precedent has been set, so we'll see where it goes from here. It's all the time we have.